Okay, cracking the code 3rd edition, we are in the glossary, starting in the D's section. Okay, de facto, in fact, indeed, actually. This phrase is used to characterize an officer, a government, a past action, or a state of affairs which must be accepted for all practical purposes, but is illegal or illegitimate. Thus, an office, position, or status existing under a claim or color of right, such as a de facto corporation. Black 6th. Compare to de jure. See note, color of law. Note, the U.S. government is a de facto corporation, which is bankrupt and insolvent. De jure, law, Latin, as a matter of law. Existing by right or according to law, Black 7th. Descriptive of a condition in which there has been total compliance with all requirements of law, of right, legitimate, lawful, by right and just title. In this sense, it is the contrary of de facto. Compare to de facto, Black 6th. Debt. Debt is not defined in the Uniform Commercial Code. Debtor. Debtor means any of the following. A person having an interest other than a security interest or other lien in the collateral, whether or not the person is an obligor. B. A seller of accounts, chattel paper, payment intangibles, or promissory notes. C. A consignee. UCC 9-102A 28. A person or business that owes money or is otherwise obligated to pay another party. See note, location of debtor. Note, your straw man fits in A above. Let's look at A again. A person having an interest other than a security interest or other lien in the collateral, whether or not the person is the obligor. Your straw man fits in A above. A debtor is as enslaved as he is obligated. The Federal Reserve issued credit to the United States government against the all capital letters trade name of your straw man shortly after the birth of the 2U, see birth, thus incurring the obligation to repay the credit, Federal Reserve notes, that was loaned. However, since the straw man has no body and no means of repaying anything, the burden becomes yours as a physical recipient of all the benefits, that is, transmitting utility benefits, that has been bestowed upon you throughout your entire life in exchange for the government's use of your trade name. Your straw man's all caps trade name is referenced above as your name only because it is a piece of property that you own, but legal title is held by government before redemption. Your straw man's trade name is an artifice existing only by force of and in contemplation of law and neither references you nor identifies you. Your true name, written in accordance with the rules of English grammar, more closely identifies you, but is still only another piece of property. See appellation. Default. The omission or failure to fulfill a duty, observe a promise, discharge an obligation, or perform an agreement. In practice, omission, neglect or failure. When a defendant in an action at law omits to plead within the time allowed him for that purpose or fails to appear on the trial, he is said to make default, and the judgment entered into the former case is technically called a judgment by default, Black's first. Defaulter, one who makes default, one who misappropriates money held by him in an official or fiduciary character, or fails to account for such money, Black's first. Defendant, Defendant includes a person in the position of defendant in a cross-action or counterclaim. See UCC 1-201-13. See action or set-off. Delivery. With respect to instruments, documents of title, chattel paper or certificated securities means voluntary transfer of possession. UCC 1-201-14. A voluntary transfer of title or possession from one party to another, a legally recognized handing over of one's possessory rights to another, where actual delivery would be cumbersome or impossible. The courts will find a constructive delivery sufficient, provided the intention is clearly to transfer title. Barron's third. Note, see pledge. Note, did your mother voluntarily deliver you into the warehouse district or county? Another delivery occurs when the U.S. government accepts the document of title or birth certificate associated with the trade name / sovereign newborn is pledged or transferred by written endorsement, receiving in return a birth certificate, that is to say, a token, a warehouse receipt, or a filled warehouse receipt, as evidence of said delivery, pledge, or deposit or transfer. The UCC authorized your mother to do this as your representative at Section 3-402. Denial. A traverse in the pleading of one party of an allegation of fact set up by the other. A defense. Black's fourth. See traverse, traverser. Deposit account. Deposit account means a demand, time, savings, passbook, or similar account maintained with a bank. The term does not include investment property or accounts evidenced by an instrument. UCC 9-102A-29. Dignity in English law. An honor, a title, station, or distinction of honor. Dignities are a species of incorporeal hereditaments. Hereditaments. There we go. In which a person may have a property or estate. Black's first. Noun. 1. A state of being noble. The state of being dignified. 2. An elevated title or position. 3. A person holding an elevated title, a dignitary. 4. A right to hold a title of nobility, which may be hereditary or for life. Black seventh. Note, an attorney's English title of nobility comes from his or her dignity. Discharge, the opposite of charge, hence to release, liberate, annul, unburden, disencumber. In the law of contracts, to cancel or unloose the obligation of a contract, to make an agreement or contract null and inoperative. Discharge is a generic term. Its principal species are rescissions, release, accord, and satisfaction, performance, judgment, composition, bankruptcy, merger. Black's first. To satisfy or dismiss the obligations of the contract or debt, the method by which a legal duty is extinguished. See note. Note, because of the bankruptcy of the U.S. government, as memorialized in House Joint Resolution 192 of June 5, 1933, HJR 192, it is no longer possible to pay off and extinguish debts. We used to be able to pay off debts using species, that is gold and silver coin, but that was declared against public policy in House Joint Resolution 192. Now we can only discharge debts by passing debt paper or Federal Reserve notes as, quotes, legal tender, unquote. Dishonor, a term applied to the non-fulfillment of commercial engagements. To dishonor a bill of exchange or promissory note is to refuse or neglect to pay it at maturity. Bouvier's 8th. In mercantile law and usage, to refuse or decline to accept a bill of exchange, or to refuse or neglect to pay a bill or note at maturity. A negotiable instrument is dishonored when it is either not paid or not accepted according to its tenor on the presentment for that purpose, or without presentment where that is excused. Civil Code, California, Section 3141, Blacks First. Tenor. By the tenor of an instrument signifies the true meaning of the matter therein contained. Cowell, Bouvier's 8th. Disputable presumption. A species of evidence that may be accepted and acted upon when there is no other evidence to uphold contention for which it stands, and when evidence is introduced supporting such contention, evidence takes place of presumption, and there is no necessity for indulging any presumption. A rule of law to be laid down by a court which shifts to the party against whom it operates the burden of evidence merely. Black 6th. See note, rebuttal, presumption, legal fiction. Note, right to legal title of your straw man is a disputable or rebuttable presumption that was presumed by the U.S. government and can be successfully disputed and rebutted. No one holds a higher claim or title of your trade name than you, because you comprise the sole source of its existence and have acted as surety for its misadventures since you attained the age of majority and became legally responsible for your own actions. District of Columbia, D.C. A territory situated in the Potomac River, and being the seat of government of the United States. It was originally 10 miles square and was composed of portion of Maryland and Virginia ceded by those states to the United States. But in 1846, the tract coming from Virginia was retroceded. Legally, it has neither a state nor a territory, but is made subject by the Constitution to the exclusive jurisdiction of Congress. Blacks First. A portion of the country, originally 10 miles square, which was ceded to the United States by the states of Virginia and Maryland, over which the national government has exclusive jurisdiction. Bouvier's 8th. See United States, see note. Note, a municipal corporation incorporated February 21st, 1871. And there's your references there. An act to provide a government for the District of Columbia. And that's where it's reorganized. Document. Document means a document of title or a receipt of type described in Subdivision 2 of Section 7201. UCC 9-102A30. See note. Note, a birth certificate is a document of title for a trade name. A receipt of the kind described in Subdivision 2 or Section 7201 is a warehouse receipt. Therefore, a birth certificate, a document of title, is a warehouse receipt. See UCC 7-202. Document of title. Document of title includes bill of lading, dock warrant, dock receipt, warehouse receipt, or order for delivery of goods evidencing that the person entitled under the document has the right to receive, hold, and dispose of the document and the goods it covers. UCC 1-201-15. See note title. Note, a birth certificate qualifies as a document of title because it is both a warehouse receipt and a dock receipt. Draft. Draft. An order in writing directing a person other than the maker to pay a specified sum to a named person. Drafts may or may not be negotiable instruments, depending on whether the elements of the negotiability are satisfied. Draft is synonymous with bill of exchange. Barron's third. Draft means a draft as defined in section 3.104, or an item, other than an instrument that is an order. UCC 4.104.7. An instrument is a note if it is a promise, and is a draft if it is an order. UCC 3.104.E. Compare sight draft. All right, under instrument, instrument means a negotiable instrument. UCC 3.104.B. Drawee. Drawee means a person ordered in a draft to make payment. UCC 3.103.2. So a drawee is one to whom a bill of exchange or a check directs a request to pay a certain sum of money specified therein. In the typical checking account situation, the bank is the drawee, the person writing the check is the maker or drawer, and the person to whom the check is written is the payee. Barron's third. Compare acceptor. See note. Drawer. Drawer means a person who signs or is identified in a draft as a person ordering payment. UCC 3.103.3. See note. Note, when you sign a check, you are the drawer and you are ordering your bank, the drawee, to pay a sum certain to the order of the payee. Draw or droit. French. This is for right. A legal right or claim to the whole body of law. Black seventh. Draw. Noun, law French, double right. History. The unification of the right of possession with the right of property, also termed jus duplicatum. Drate. Black seventh. See note. Compare absolute rights. Note. As with the Sesticay Trust, this term also comes to us from Norman French attorneys. You have had the right of possession of your juristic strawman trade name your entire life, but you have been denied title, the name of property, because it is held in custody elsewhere in the State Registrar. The process contained herein unites right of possession with right to hold your property or trade name. Doulocracy. Greek, doulos, servant, kraton, to rule. A government in which servants or slaves have so many privileges that they essentially rule. Compare mixed war. Black seventh. Dummy. Noun. One who purchases property and holds legal title for another, usually to conceal the identity of the true owner, a strawman. Adjective. Sham, make-believe, pretended, imitation. Person who serves in place of another, or who serves until the proper person is named or available to take his place. For example, dummy corporate officers, dummy owners of real estate. Black sixth. See note. Dummy corporation. Note. Your strawman is a dummy and serves in the place of another, you. When the strawman's trade name is called in court and you answer up, you become the proper person and are available to take his place and do. This is how the switch takes place. See impropria persona. Dummy corporation. Corporation formed for sham purposes and not for conduct of legitimate business. For example, formed for sole reason of avoiding personal liability. Black 6. See note. Note, the United States government formed the dummy corporation identified as your trade name, with neither your mother's nor your knowledge or consent, for the purpose of making you personally liable for repayment of loans of credit from the Federal Reserve, e.g., exempli gratia. That means, for example, EID number. Note, see note. Note, EID number is a unique numerical identifier bearing similarity with employer identification number, EIN, and Social Security account number, SSAN, just as IRS and state tax agencies denote the dashless SSAN, for example, 1, 2, 3, 4, 5, 6, 7, 8, 9, without dashes. As the account number and case number, we insert a single dash after the fourth digit and call it the EID number. For example, 1234-56789. Once you achieve standing as creditor over your strawman debtor trade name, you also acquire standing as employer because you, as creditor, are accorded with the same standing as any other creditor. It is not unfeasible to consider your strawman Social Security account number with a single reposited dash as a unique EID number for you, the new employer. Employee. For purposes of this chapter, the term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of a corporation. Internal Revenue Code, Section 3401D, Subtitle C. Employer. For purposes of this chapter, the term employer means the person for whom an individual performs or performed any service or whatever nature as the employee of such person, except that 1. If the person for whom the individual performs or performed the services does not have control of the payment of the wages for such services, and term employer means the person having control of the payment of such wages. Internal Revenue Code, Section 3401D, Subtitle C. Employer Identification Number, see EID number. Ens legis, Latin, a creature of the law, an artificial being, as contrasted with a natural person. Applied to corporations, considered as deriving their existence entirely from law. Black's Fourth, see note. This is a precise legal description of the all capital letters named strawman trade name. Equity. Law. The application of the dictates of conscience or the principles of natural justice to the settlement of controversies. B. A system of jurisprudence or a body of doctrines and rules developed in England and followed in the United States, serving to supplement and remedy the limitations and inflexibility of the common law. ACD. Most generally, justice. Historically, equity developed as a separate body of law in England in reaction to the inability of the common law courts, in their strict adherence to writs and forms of action, to entertain or provide a remedy for every injury. The king therefore established the High Court of Chancery, the purpose of which was to administer justice according to the principles of fairness in cases where the common law would give no or inadequate redress. Equity law, to a large extent, was formulated in maxims such as equity suffers not a right without a remedy, or equity follows the law, meaning that equity will derive a means to achieve the lawful result when legal procedure is inadequate. Equity and law are no longer bifurcated, but are now merged in most jurisdictions, though equity jurisprudence and equitable doctrines are still independently viable. Barron's third, see note. Note, this is a very nobly described and apparently altruistic form of law, and may have been so at one time. Today, equity has much more insidious implications because it is founded entirely on the conscience of the court. That is to say, literally whatever the judge wants to do. See Admiralty Law, Vice Admiralty Law. Note at Barratry. Escrow. Scroll. A written instrument, such as a deed, temporarily deposited with a neutral third party, the escrow agent, by the agreement of two parties to a valid contract. The escrow agent will deliver the document to the benefited party when the conditions of the contract have been met. The depositor has no control over the instrument in escrow. In common law, escrow applied to the deposits of instruments for conveyance of land, but now it applies to all instruments so deposited. Money or property so deposited, also loosely referred to as an escrow. Barron's third. Esquire. A member of English gentry ranking immediately below a knight. A man belonging to the higher order of English gentry, ranking immediately below a knight, applied to various officers in service of the king. In the U.S., the title belongs officially to lawyers. Oxford English Dictionary. Originally a shield bearer or armor bearer, an attendant on a knight. In modern times, a title of dignity, next in degree below knight and above gentleman. In English law, a title of dignity above gentleman and below knight. Black's first. See the truth about esquires in Part 1, Section 2. Estop, to stop, bar or impede, to prevent, to preclude. Black's first. Estoppel. Party is prevented by his own acts from claiming a right to detriment of other party who was entitled to rely on such conduct and has acted accordingly. An estoppel arises when one is concluded and forbidden by law to speak against his own act or deed. Estoppel is a bar or impediment which precludes allegation or denial of a certain fact or state of facts in consequence of previous allegation or denial or conduct or admission, or in consequence of a final adjudication of the matter in a court of law. It operates to put party entitled to its benefits in same position as if thing represented were true. Estoppel is or may be based on actual or constructive fraudulent conduct, admissions or denials by which another is induced to act to his injury, agreement on and settlement of facts by force of entering into contract, concealment of facts. Black's fifth. Et sequentia. And the following. Thus a reference to page 1, et sequentia, means page first and the following pages. Black's first. Ex parte. One side only. By or for one party. Done for, in behalf of, or on the application of one party only. blacks first. All right, so that was the D and E section. Next time we'll start the F's of the glossary.